done it. We download an app, we just click it, right? Accept without reading a single word of that fine print. Well, maybe the story will make you think again.
A couple in New Jersey was severely injured after their Uber driver sped through a red light and was T-boned by another car. They pushed for a jury trial, but a court ruled that they can't sue the company because they and their daughter agreed to arbitration when they accepted the terms of service for a separate Uber Eats order. Joining us now to discuss is defense attorney Misty Marris. Misty, thanks so much for sharing part of your afternoon with us. The couple claimed that their young daughter was the one who accepted the terms while using their mom's phone. She wasn't 18, but she said that she was 18 when she signed up for the terms of service. What do you make of this whole case?
Right. So that argument was one of the two arguments that were raised by the plaintiffs here. First, it comes down to whether or not the couple, the actual parents, and the plaintiffs in this case consented to this arbitration agreement. So they raised the argument that their daughter, who was not 18 years old, was the one who actually clicked that box. The court ultimately determined that there was evidence that the mother had actually accepted the terms and conditions prior to that time. And then also testimony had indicated that they weren't really clear on what daughter had seen. They just did not remember seeing that click box that talks about arbitration popping up on the phone. So the court actually said that's an argument for the arbitration, but it's not going to preclude you from being bound by this arbitration agreement.
Okay, let's put aside that, Misty, the whoever it was who clicked on it. I think people look at this story and they say, wait, so it was a separate Uber Eats order, but this was an Uber, this was a drive, right? What does my Taco Bell have to do with my taxi ride in a way? What's the answer?
No, absolutely. Certainly that's the takeaway here. So putting that issue aside, the next issue, and all of this is a matter of contract law. The next issue, when this box pops up and it provides these new terms and conditions that, by the way, you have to click in order to use the app, and in order to use the app for both Uber Eats and the Uber Rides app, well, if you don't click it, you cannot use the service. So the question is, was that open and obvious? What was the writing like? What did it actually say? And in this particular case, that box that popped up not only discussed the obligations of a consumer with the Uber Eats component of the app, but also said that those same obligations, including the arbitration provision, applies to the Uber Ride app as well. So the overall answer to the question is the language matters, and it's going to be different in every case. This leads into what the part of the argument was, that these are the type of terms and conditions, 12 pages, you're scrolling through it on an app screen. All the bargaining power is with the company and none on the consumer. But here the appellate court found that the language itself did cover the Uber Ride as well, and that it was very pronounced, that it was obvious that there were new terms and conditions which were ultimately accepted.
I did not consider any of this when I went for that cheesy gordita crunch. Misty, is there a way ever to get out of the terms of service?
This is why I imagine we're going to be seeing so many of these cases working their way through the appellate courts, because that bargaining power lies only with the company. And as we move into a consumer framework where there's all of these applications, where we're using apps essentially in every aspect of our lives, we have to ask ourselves as consumers, where's the protection? And the answer, Boris, is unfortunate, because it's not like a contract where you might sit down in a room and you both have a lawyer and you're hammering out the details, or you're talking to a contractor or a service provider. No, it's either you click yes or you don't use the service. So I think these issues are going to be hashed out as they continue to climb up the courts. And there has been a movement where decisions have moved more towards the consumer-friendly side. And that's because, as we talked about, it's a contract. And in contract law, the drafter of the contract, there's an inference that the language is more beneficial to them. So it's a difficult road.
It seems like it's apples and cinnamon twists or burritos.
And man, when they have you by the cheesy gordita crunch,
the cheesy gordita, it's so good. Or the chalupa supreme. Those are my go-tos.
Very good.
Misty Marris, appreciate you joining us.
All of them. You gotta love Taco Bell.